Mr President, I rise today to speak about the Children and Young People Safety and Support Bill 2024, and in doing so I indicate that I will be the lead speaker from the opposition, the Legislative Council, on this bill. Mr President, there were repeated calls from the opposition and from the crossbench for this crucial legislative reform to be brought to this parliament after great delay. The report for the review of the Children and Young People Safety Act 2017 is dated February 2023. This bill was introduced to the Parliament in October of 2024, roughly around 20 months after the report for the review of this Act. Despite this, the community was given a month for consultation on the draft bill. From speaking with stakeholders, it was clear that the consultation period of 1 month was not sufficient. The feedback we received was that many in the child protection community have busy schedules, some of whom are volunteers, and a month to consider the draft bill, a bill that is quite lengthy, especially in such an important and complex area, to engage with their stakeholders and to be able to draft a submission within that time was not practical for so many. After speaking with stakeholders, the Shadow Minister for Child Protection, Josh Teague MP, and I wrote to the Minister for Child Protection to seek an extension of time for the consultation period by 4 weeks. This was a request that was promptly denied by the Minister on the exact same day that that request was made. It was our view that an extension of 4 weeks would give the community a greater chance to consider the draft bill, but would still have provided the Minister with ample time for the final bill to be brought to the Parliament by the end of the year after appropriate consideration and consultation. Community consultation period, in our view, should not be rushed, because the government is all of a sudden in a rush themselves to have movement for this crucial legislative reform. It is not every day that we have the opportunity to reimagine the framework in which the child protection system rests. As such, it is vital that we get this right. This gives us the immense opportunity to create substantial generational change. This is not an opportunity we get every day, but with it too can bring the risk of unintended consequences of new provisions in the bill that would adversely impact the rights and the well-being of children in state care should the bill not be properly considered and not be properly consulted on. It is our belief that key to this is listening to the organisations, listening to carers, to stakeholders, to the commissioners, the Guardian, and those with lived experience on their thoughtful and their considered feedback on this bill. Earlier this week, members of this place will have received a co-authored letter by South Australia's Guardian for Children and Young People, Commissioner for Aboriginal Children and Young People, and Commissioner for Children and Young People, calling on the Legislative Council to refer this matter to a parliamentary select committee on the Children and Young People Safety and Support Bill 2024 for further consideration. To quote from this letter, it says, "The reason that we call for this Parliamentary Select Committee is because the intent and scaffolding for reform is evident, but the bill is simply not ready and further consultation is required." The letter goes on to say that, as experts in this field and on behalf of children and young people in South Australia, we have substantive advice and evidence to provide government on required legislative reform. To date, our advice and evidence has not been heeded. We ask the Legislative Council to provide us with another hearing, end quote. This letter further goes on to say, this advice has been ignored and government has not answered why. Mr President, for officers of statutory bodies to not have their advice or evidence heeded by the government with no answer as to why, leaving them to call for this bill to be sent to a select committee by the Legislative Council is quite extraordinary, and frankly this is something that the Minister needs to address. The call to refer this bill to a select committee has been supported by the Aboriginal Legal Rights Movement, the South Australian Aboriginal Community Controlled Organisation Network, Relationships Australia SA, South Australian Council of Social Services or SACOS, Concerns have been raised around the lack of consultation that was undertaken around this bill, in addition to many other concerns as well. To quote SACOS, they state, "We recognise the issues and concerns raised by these three independent bodies statutorily appointed to advocate for the rights, best interests and well-being of children and young people in South Australia have a significant bearing on the framing and future impact of this legislation," end quote. The Honourable Tammy Franks has a contingent notice of motion in her name that I understand she intends to move to refer this legislation to a select committee after the bill is read a second time. I indicate that the opposition will be supporting the referral of this legislation to a select committee. In doing so, I wish to indicate that it is crucial that this process be dealt with expeditiously, but thoroughly. The calls that have been made by Commissioner Laurie, Commissioner Connolly and Guardian Reid cannot be ignored. As a parliament, we have the opportunity to enact real and meaningful change to the lives of so many vulnerable South Australian children, and we cannot afford to get this wrong.